Greetings, greetings, greetings. One second. Give me 1 second. Testing, 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 testing. Greetings, 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 greetings. I am King Clifford Jefferson, descendant of Godfrey, the fifth Contraband Jew, son of folk, ruler of Jerusalem. I am the personification, the reincarnation, or the incorporation of the capacity of the office that was held by our ancient forefathers who were kings or queens, and that has been secularized in modern day based upon the revised statute that was created by way of what we call a prospective prospective law that reached back through time retrospectively and created what we call a preservation of a statutory exception, which is a law that was passed by our ancestors that it to be preserved and used prospectively, meaning going forward. All right. So today's lesson is how to reclaim your capacity to have an interest in your property, i.e., your house and the land that it sits upon. Okay. This is very important for all those who claim to have the right to inheritance for the little bit of an estate that you have. Okay, and the only way this can happen is by way if you formally gave the world notice that you are in the possession of said property by way of what we call a standard deed. Okay, a standard mortgage deed. All right, very important that you understand. This is well, the lesson will tell a tale. Okay, so once again, how to reclaim your capacity to have an interest in your property, i.e., your house and your land. And it can only come by way of your spiritual capacity. Okay, your spiritual capacity. All right, because your spiritual capacity and your secular or human capacity works together. Okay, is a contract, okay? Is an agreement, all right? And I'm going to explain that in detail today. So hold on to your your seat because this is going to be a good one, okay? And I'm going to show you everything via the laws, uh, the language, all right, so that we can apply this in modern day, okay, to help each and every one of us regain our estate. Because one of the most vulnerable things that we have in our possession is our property, okay, let alone the cars, the clothes, and all the other personal property. But one of the main assets that we have is our property. Okay, very important for those of you who have property. So you can go to whatever channel you want to go to, or listen to whoever you want to listen to. But if you don't have these essential keys of understanding, then you will forever be in the state of what we call a debtor. Okay? By way of you playing the characteristics or the position of what we call an accomplice or a willing participant. Okay? It is, in fact, your choice only. Okay? I will teach you how to be able to start the process of acquiring the title of your said property, wherever that property sits in, whatever state you sit in, whatever county that the county recorders have filed your standard deed in. You have a way out, okay? And it only is through understanding the capacity and interest that runs with the land, okay? I've been talking about this forever, but for some of you, we seek for wisdom in high places, and when you realize that wisdom is not there, it's a far fall from where you started from. Okay, so without further ado, let's get started with this beautiful lesson. Like, share, subscribe, donate if you can to $ Clifford Jefferson L to help assist me in the progression of our understanding and knowledge of our capacity and interest that runs with the estate that we have or we will have based upon the promise of that inheritance. Okay? This is a retained, unenumerated right that your ancestors have preserved for you. Okay? Very important that you comprehend. All right, so let's get started. I always like to show images, visuals, so we can comprehend what's being said. Once again, the grantor is your ancestors. Okay? Is your ancestors. Those who are no longer here, physically, living in the secular life. Though they had a spiritual life, they're no longer living their life. And each of those life, whether it's spiritual or physical, has a capacity. Okay? In order for the grantor to be standing on the land, he must have just soil inheritance. He also must have just sanguineous right of blood to retain property. And to transfer that property is to remain either in two forms, fee simple or entail. If it's entail, meaning that even though the grantor, the heirs, transferred it to the predecessors, which are the successors, they are not allowed to subinfeudate that land, which means to sell it to anybody other than a family member. Okay? But through the assistance or through the help based upon willing participants or accomplices, we have now capitulated to the subinfeudation of our land granted by our grantor, our ancestors, whether you talk about land, whether you're talking about property, whether you're talking about personal property, as well as what we call finances, okay? All this has been thrown away, okay, as a result of a interstate claim, okay? Meaning that they're saying there are no heirs. When we say heirs, we're talking about citizens. When we talk about citizens, we're talking about nationals. When we're talking about nationals, we're talking about the people. Okay? Very important. All right? So somehow, some way, we have lost our connection to our inheritance as heirs from the inheritance that was transferred or conveyed to us by our grantor, which consists of houses, lands, cars, monies, etc. But somehow, not just the property, personal property, but us as well has fallen to a position of what we call interstate. Okay? Interstate by way of a practice created by lawyers called common recovery. Write that down. This is a New Jersey real estate book on real estate, land, property. Okay, very important. All right, Essentials of New Jersey Real Estate, 12th edition. This real estate book teaches those who have a practice in real estate, okay, how to convert a intel estate into fee simple, okay, how to convert a intel estate into fee simple, and this is by way of transfer of title, okay, transfer of title. Title to real estate means the right to or ownership of the land. A parcel of real estate may be transferred from one owner to another by the living, or it may be transferred by will or descent after a person has died. In every instance, however, alienation, also called subinfeudation, the transfer of title to a parcel of real estate, is a complex legal procedure involving a number of laws and documents. Alienation of title. This is governed under New Jersey Revised Statute 46:3-15, New Jersey Revised Statute 46:3-5, and New Jersey Revised Statute 46:3-6. These are, or this is the statute governing the property in New Jersey, okay? And what these statutes represent is the amending of our ancestors' ancient law, which was called folk right, okay? Folk right, okay? through these statutes, you're going to see that the legislator took it upon themselves to prospectively create laws to reach back in time retrospectively and amend or repeal or dissolve laws that existed before the creation of the legislator. Okay? This is an ultra virus act which calls for declaratory and injunctive relief. Okay? And it only comes to two ways, either voluntary alienation, which is called voluntary subimputation, or involuntary alienation or involuntary subimputation. Okay? And they're contrary to the very historical laws where these statutes were retrospectively repealed or dissolved. Queen Pretorius was passed by Edward III, King of England, which said that you could not alienate or subimputate the land. 46.3-5 deals with, 46.3-15 deals with the donuts conditionalibus, an entail estate, and 46.3-6 deals with land that's allodial. But all this links back to one statute, 46:3-2, okay, which we'll discuss in a second. So we have voluntary alienation, then we have involuntary alienation, which says that title to property can be transferred by involuntary alienation, that is, without who? The owner's consent. That means you. Okay? That means you. Those who have a property deed filed in the county recorder's office, this is talking about you, the actual owner, because you are in possession of it. What they're doing is erasing your capacity as an owner, okay? And have made you what? A consumer, because now they're saying that you have purchased the property under a contractual agreement by way of a document called a mortgage, which becomes a lien, a voluntary lien that you allow because you have become a warranty voucher. Okay? Listen up, brothers and sisters. When a person dies interstate and leaves no heirs, the title to his real estate passes to the state by way of an escheat. How many know what escheatment is? You need to write that word down. It said escheat. Now, I've taught this many times throughout my classes that I have on this platform. So we ain't talking about voluntary alienation. We're talking about involuntary alienation without the owner's consent. Without the owner's consent. This takes a process or a procedure to be able to take property without the owner's consent. This is usually done through what we call the police powers. Okay? The police powers of all the states, of any state within the United States that they call America. Okay? We are English American citizens. Okay? We are English American citizens. You would want to pay attention to this lecture. Action. This is the procedural administrative process. This is not substantive arguments. This is procedural argument. Okay? Person dies interstate. That means based upon their records, you're not a citizen. Okay? You're not a national. You're not of the nation from where you descend from in order to have an interest in a somewhat of what we call an inheritance. because your ancestors have died and gone. But there must be some type of procedural process to transfer an estate from a dead person to a live person. This is what we call, what's the term? Uh, Legal term. What's that term called? Statutory. What's the term? It'll come to me. A person dies in the state with no heirs, and when the person dies, that land, that property, whether it's personal or real, escheats to who? The sovereign, the one who says they are the sovereign, which is an entity called the state of New Jersey. Okay, an entity called a state of New Jersey. They do the eminent domain power. Escheatment is one of the sovereign powers of the state. The next power of the state is eminent domain. This is the sovereign power of the state. Escheatment, eminent domain, okay, which is the power to take private property for public use. Okay? The next, because there's four pillars. Escheatment, eminent domain, foreclosure, okay? Foreclosure. This is the process that they use to take your property when you fail to meet the requirement of what we call a mortgage contract. Okay? A mortgage contract. Then they have set up a fake judiciary system to administrate the transfer of the property as a result of the mortgage, the pledge that you became a debtor on because you did not pay it back. There was a lien placed on your property because of a loan. The loan or the lien or the encumbrance does not mean that the one who loaned you the loan owns the property, because the deed on the county recorder office says you're the owner of the property. But they have a lien on it because of a loan that they supposedly gave to you, the citizen, the national, okay, the one of the people. When we look through their closing process, they have skipped a step. And I'm going to show you that right now. For every one of you who have a deed on the county recorder's office, which was recorded after the closing, after the meeting of the minds. How many of you have heard of that term? The meeting of the minds. Okay? In order for you to have a mind, you got to be a human being. In order for you to be a human being, you got to be classified as a natural person. And to be a natural person, you must be a living person. And they only need to tell you that by way of what you call your birth certificate. The birth certificate shows that you were born, all right, in a specific territorial boundary, okay? It gives you a limited capacity, not full capacity, but a limited capacity. It does not give you a visual identification because that comes through what we call a photograph. Very important to understand the two terms: status, capacity, and visual identification. Okay? Once again, verification. Visual identification and status capacity is what the documents that we receive from the state of New Jersey is supposed to determine. Okay? Very important. Get your pen and papers, brothers and sisters. You're going to need this. Because I'm going to teach you how to save your estate. So we have to acknowledge, okay, the one who brought this material to you, okay? Very important. Because this entire statutory analysis is for teaching and educational purposes, but it is legal advice, okay? Most people, most platforms that you go to always state that it's for teaching and educational purposes, but it's not legal advice. This fits the requirement of all three. It is a teaching, it's educational, but it does give legal advice because this is all about legality and capacity. Okay, it's all about legality and capacity. Okay, so if you don't have any legality, you don't have any capacity to teach or educate somebody about something that you don't know the law on. How many of you can understand that? So you have to give acknowledgement when acknowledgement is due. Because this entire statutory analysis is a teaching and educational purposes, we can analyze this complex legal matrix as a highly sophisticated masterclass in jurisprudential logic, statutory construction, and institutional underwriting vulnerabilities that I discovered, okay, in regards to the contract that was created, not by you, but by the banks, okay? Very important, by the banks. When studied as an academic or pedagogical model, this exercise exposes the friction between automated corporate compliance systems and the literal text of a state statute. Very important. Because when you sign these contracts are pre-written. Okay? Pre-written. So here's a conceptual breakdown of the primary lessons this theoretical legal framework that I'm going to teach you today falls under. And I'm going to use New Jersey revised statutes to qualify everything that I'm saying. It might not fit your state statutes, okay, because every state has different statutes, have different codes, have a different constitution, all right? So very important that you interface that with your state statutes, constitution, because they all say the same exact thing, all right? Lesson 1, the principle of bifurcated legal instrument. All right? The principle of I'm speaking too fast. Bifurcated legal system. In advanced statutory analysis, a single physical document can be split into two separate legal concepts. Bifurcated means to split. Okay, it means a fork. 1, we're talking about a legal instrument, a document. All right? A deed. 1, the visual authenticator. The document proves physical identity. Very important. New Jersey, this is governed under New Jersey Revised Statute 52:7-10.8, which commands a notary to verify that a human signature matches a face. Y'all pay attention. Visual authenticator means that the document proves the physical identity only. And this is what the statute is going to say. All right. 52 governs New Jersey's government. Okay. It gives them their capacity. They're the one who issue out these bifurcated legal instruments that we walk around with. Okay. Then there's 2. The status and capacity. This document proves political, national, and specialized jurisdictional status, i.e., capacity, i.e. citizen, i.e. national. Okay? Very important. This is in every constitution. New Jersey's is Article 1, Section 2. All right? So you have two principles of a bifurcated legal instrument, which is one for visual authentication, and the other one's for status and capacity. You, the student or a researcher, will uncover a structural flaw when a commercial institution treats a document designed solely for visual authentication as if it's automatically established substantive status capacity. I'm going to say that again. You will now uncover a structural flaw when the commercial instruments that you carry along in your pocket, all right, keeping you safe, filed in the county recorder's office or wherever you keep them, all right, are documents designed solely for visual authentication as if it automatically establishes your substantive status and capacity, especially when the state vehicle codes, like for New Jersey, under New Jersey Revised Statute 39:3-29.3, explicitly states that the documents cannot be used to prove status. Okay? We have two statutes, Title 39 and Title 52. Okay? Very important. Also with this lesson, point 2, you understand lex specialis versus automatic fintech standardizing system, which is the financial technology that banks use, okay, to create these contractual agreements, which are fraudulent once you look at it through the eyes of how I'm giving it to you, okay? This pedagogical scenario perfectly illustrates the classic clash between lex specialis derogate lege generale, the canon of construction, a specialized statutory vehicle passed by the legislator, like Title 16 1-28, which governs corporate entities, mainly called a corporation sole, which we incorporated as, which is designed for a long-term temporal sanctuary, which cannot be silenced by or overwritten or erased by a general real estate statute known as 46:3-2 or 46:3-2, which is the statute created by New Jersey governing property. Okay? When we read the statute governing property, New Jersey amended the very original intent that the statute was derived from. Okay? Because when you read the plain language of the statute, it goes back retrospectively back into time immemorial. All right, which we'll talk about in a second. So write down New Jersey Revised Statute 60:1-28 and New Jersey Revised Statute 46:3-2. Write them down. Systematic automation biasness. Okay, very important. Pay attention. Automatic lending platforms like Rocket Mortgage and all the other mortgage companies out there, i.e. banks, are coded to treat all human interactions uniformly under a standardized commercial consumer loop. New Jersey by Statute 46:3-2 that turn all estates into what we call free and common soakage. Free and common soakage. That's the verbiage of the said statute. It was amended February 18th, 19. What was it? 19. Let's go to it right now. Let's read it. certain turn into free income and soakage. This is the law. This is why our estates fell interstate, because we're no longer showing our allegiance, i.e., our pledging our allegiance to what? The king. All right? Not the king, the private person, but the corporate person, because of the corporate capacity that he holds as the king. It's an office, okay? They switched the king for a governor or a president, okay? On the federal level, on the state level, it is a governor. They switched the capacity. This was stepping into the king's shoes, okay? This says the tenures and the honors, manors, lands, tenements, or of hereditaments, or in the state of inheritance at the common law. That means our law, okay? Held either of the King of England or of any other person acting in the capacity as the King of England, now called a corporation sole, or body of politics or corporate at any time before July 4th. This is retrospectively, meaning before July 4th, 1776. It's declared now by Section 3 of an act entitled An Act Concerning Tenure passed February 18th, 1795. This is prospectively, meaning going forward now. So that means they would reach back into time retrospectively before July 4th, 1776, and declared that intel estates that were given by the king under their donors conditions of bus have now been subjugated because they have amended the king's law and now declared it on, what was it, February 18th, 1795, now to be turned into free income and soakage. All right? So they have now stepped into the king's capacity. This is an ultra virus act because they are not kings. Okay? They are acting in the capacity as trustees, known as presidents or governors, under Title 52. This is for the state of New Jersey. For the federal government is whatever statute or code they got for the president. All right? Very important, based upon their statutory code or their constitution. Very important that we understand that. So we see right here that New Jersey stepped into the shoes of the king by amending the king's statutory law, which was reserved by the legislator before February 18th, 1795. Okay? Now they have amended it and now changed your very interest in your estate. Why? Because they changed your capacity in that interest. I'm going to show you how. Systematic automatic biases. Automatic lending platforms like mortgage companies are coded to treat all human interactions uniformly under a standardized commercial consumer loop, a steady loop, an unbreakable loop. Okay, teaching this framework demonstrates how automated algorithms create a massive legal blind spot by failing to build a compliance branch capable of recognizing specific non-commercial statutory entity classifications such as a corporation sole, which is the modern day of the capacity which is stemmed or rooted in the origin retrospectively to the origin where it stemmed from, which was called the King of England, which we just read in New Jersey Revised Statute in modern day. Okay, so as a result of that, we have now been trapped into a mortgage based upon a debt and a loan that we have now duped into paying back by way of becoming willing participants by way of accompliceness. Okay, accomplice. You know what accomplice is, right? Do you know what accomplice is? Let's define that word. Accomplice. Okay. Accomplice. Everyone see that, right? As a henchman, one associated with another in wrongdoing. Okay? One associated with another in wrongdoing. Synonyms: henchman, accessory, informer, confederate, conspirator, crony, mobster, cohort, abettor, companion, comrade, collaborationist, gangster, racketeer, partner, informant, collaborator, evidence, traitor, plotter, and state evidence. These are synonymous, similar words. Okay? We also can use the term willing participant. Willing participant. So now you're trapped into a loan, all right, a debt, an encumbrance that you have contract with a mortgage company, all right, or a bank, and you don't even have the capacity to contract because there was no meeting of the minds, okay? There was no meeting of the minds. But still, they want you to act in clean hands, okay? So that's what we must do, being in such a predicament. We must still act with clean hands. So when we go before a chancery judge and lieu of equitable, what we call redemption, all right, equitable redemption, all right, we must come with clean hands, meaning that we just can't go to them saying, because we got due, we're not paying. Because you took a loan out. All right? You took a loan out. So, and we know that the whole system is rigged, all right? So it's very important that you act within strategy, especially when you're dealing with equity, that you come in clean hands. So let's take a look at that view. From a procedural litigation strategy standpoint, this is what I teach you. This is not what everybody else teach you. The payment under protest mechanism demonstrates how a litigant can shift from a defensive posture to an offensive posture, meaning that when you go before a court claiming that you own the property, and then you saying that you stop making payments on the loan because you just found out you own the property, that's not acting in clean hands because you made it a contractual agreement prior to you bringing this claim that the mortgage company acted dishonorable, all right? Very important you understand that we have to act in clean hands. So this is by maintaining the account as an active and current via automatic drafts or model which removes the emergency of a standard foreclosure, meaning you keep paying the loan. Okay? You keep paying on the loan. This allows a court of equity to focus purely on an academic or text-bound declaratory judgment action based upon capacity, all right? Your retrospective capacity that you have willingly gave up because you don't know who you are. You let them tell you who you are. Once again, it presents the judge with a pure question of law rather than a standard default dispute. Very important that you stay in with clean hands, all right? Act with clean hands. And then the last part of this lesson, part 4, we will dive into how many states within the 50 states practice the same system, okay? Messing with the algorithm and how we as parties in the contract have been made willing participants because of our ignorance of not knowing our capacity when the contract was made. Okay, very important. Finally, analyzing that other 49 states serve as the educational model for federalism. It demonstrates how the Real ID Act of 2025 systematically stripped standard state issue identification cards of their high-level political status capacity nationwide, creating a uniform nationwide underwriting vulnerability that can be studied across different state vehicle and property codes. You hear that? A vulnerability because of the confusion about visual identification versus status and capacity. Okay, that was created by undermining the very law that was put in place to stop that. Now let's dive through that. Okay, let's get it. Let's start from the beginning with the word mortgage. Write this word down. Let's start with the word mortgage. Hold that thought. Everybody wrote down the word mortgage? Write it down. The word mortgage comes from the law French term in the 14th century England, meaning a dead pledge. For dead, engaged for pledge. It was dead because the pledge ended either when the debt was paid or when the property was lost due to non-payment. So you got two choices: pay the debt and have the mortgage discharged, or lose the property for not paying the debt. Those are the only two choices that you have, especially in that status of capacity that you're in. Okay? All this goes back to how it originated from the medieval ages. Okay? So just look how it worked in the medieval ages. First, you had a transfer of title. The borrower signed a deed, a standard deed, the same one that's filed in the county court office, that actually transfers the land ownership to the lender. The lender is the one who loaned you the money to assume that you purchased the property, but he don't own the property. He only loaned you money to assume that you purchased the property. Okay, so he has an interest in it, an encumbrance. All right, very important you to understand that. He's a lender, the one who gave you a loan. He's not in it for continuity of possession. He's in it to make money. Interest, profit, that's what he's in it for. So you have a transfer of title, then comes the possession and profits. Okay? Back in the Middle Ages, back in the days of the colonists, before they created the dollar bill, they didn't have gold and silver. They used their crops. Lenders often took physical possession of the land or collected its crops profits, applying the money towards what? The loan. Okay? The loan. Okay? And on that very day, based upon the contract that the loan was supposed to be paid off, that was called the law day. Judgment day. Okay? Doomsday. William the Conqueror called it the Doomsday Book. Return of the owner's land. Let's pull that up. Doomsday. You call it the Apocalypse. Why do they do that? They don't want to pay back what they owe you. Doomsday Book. Doomsday Book, the Middle English spelling of Doomsday Book, is a manuscript record of the Great Survey of much of England and parts of Wales, completed in 1086 by William the Conqueror. The manuscript was originally known by the Latin name Liber de Wettonia, meaning the Book of Winchester, where it was originally kept in the royal treasury. The Anglo-Saxon Chronicles state that in 1085, the king sent agents to survey every county, which is called shire in England, to list his holding and dues owed to him. Y'all better pay attention. Y'all better pay attention. The name Doomsday Book came into the use in the 12th century by Richard Fishnell, wrote it in the Dialogus de Cascario in 1179. That the book was so called because its decisions were unalterable, like those of the Last Judgment, and the sentence could not be squashed. Did you hear that? Last Judgment, Judgment Day, is a central Christian eschatological event marking the return of Jesus Christ to evaluate all of humanity, both living and the resurrection dead. Y'all better listen to me, okay? Y'all better listen to me. I'm not just doing this for fun. Now let's see this medieval practice evolve. So possession and profits back in the Middle Ages was collected not by money but by crops and profits paid to the lender to pay off the loan. But on law day, contracts set a strict final repayment date. For those who have mortgages, it's 30 years. Okay? If paid, the loan returned to the owner. If missed, the property was permanently forfeited. Okay? Forfeited. This is why you have foreclosure courts, brothers and sisters. Okay? When they foreclose on you, they allow equitable redemption, which means they allow you time to pay off that loan. But if you miss it, if that sheriff sale come up, you asked out. Okay? Very important. Let's see the evolution of that law. Vulnerability. Early borrowers risk the total loss of their estate if they miss the deadline by even one single day or one single payment. Don't pay your mortgage on that month, they will have your ass in court. Okay? Not chancery court, not probate court, but foreclosure court. But now you have what we call equity of redemption, which you didn't have in the Middle Ages. Later in the Middle Ages, courts began allowing a grace period, a right for borrowers to reclaim land even after the deadline has passed, forming a basis of modern foreclosure and redemption law. Did you hear that? So is mortgage loan feudal in origin? Let's see. Is feudal loans or mortgage loan feudal in origin? We just read the Doomsday Book from William the Conqueror, all right? And they connected that to the Judgment Day concerning the return of Christ, the Messiah, the Anointed One, okay? So the modern mortgage loan is deeply rooted in the feudal system of medieval England, okay? After the Norman conquest in 1066, all land ownership flowed from the king down to tenants through a strict hierarchy. Feudal roots of the modern mortgage. Land tenureship, true ownership, belongs to the king and lords held land under specific duties, military, service, crops, or rent. All right? The gauge system. Under feudal property structure, two types of land pledges developed. The vive gauge, which is a living gauge, where land properties pay off the debt, and then you had the mortgage, debt pledge, where properties were entirely to the lender as interest, profits based upon possession. Very, very, very important, because who brought in feudal law? William the Conqueror. Feudal law started from 1066 and didn't stop till New Jersey passed this law right here. Okay. This is the legislative statute, and it mentions the King of England retrospectively had control of everything, had control of all tenures, all honors, all, let me just get it right. So before July 4th, 1776, all tenures, honors, manors, lands, tenements, or hereditaments, or of an estate of an inheritance, meaning that any estate that you could inherit under the common law of England was held, pardon me, either by a king of England or anyone acting in that capacity, and that because it said any other person or body politics or corporate at any time before July 4th, 1776. That was the first constitution of the United States of the states, and that was a constitution of New Jersey, okay? Then you had the 1844 Constitution, which were two separate capacities that they don't have now, because now they're acting under the 1947 Constitution. So they cannot reach retrospectively back in time and alter things that did not exist when they were created as a body of politics in 1947. You are not listening, okay? All right? So prior to July 4th, 1776, there was a king. There was a king here. How do we know that? We go right here. Sorry. New Jersey Provincial Council. You can run from this truth if you want to. Right there. The authority in 1702 to 1776 was the crown. Okay? The crown of England. Okay? Under the authority of a Scottish queen, Queen Anne. All right? Very important. Until it was overthrown by William Paterson. Okay? They locked up the last world governor, which was William Franklin, the illegitimate son of Benjamin Franklin. Okay? Right here. This was the overthrow. Right there. So you have to know your history. When we go back to New Jersey statute, the King of England was rocking here all the way up to July 4th. Sorry about that. Even after that, it was the crown functioned all the way up to February 18th, 1795. The crown operated from time immemorial all the way up to February 18th, 1795. That's when the state of New Jersey, as a corporate entity, decided to step into that capacity. Right there. They decide to step in that capacity, but don't have the authority to do that. Why? Because William the Conqueror issued the Doomsday Book, which said that one day all the land will return back to the king. We know that Era 66 till this statute right here. Feudal tenures were abolished. So New Jersey reached all the way back prospectively into time, retrospectively, and abolished everything that was done by William the Conqueror. What does that tell you? The feudal tenures of states and interests thereof taken away, discharged, and abolished from and after March 12, 1664. That was the charge given to George Carteret and John Berkeley. All this authority and capacity was surrendered back to the crown in 1702. Okay? We know that because right here, the next statute, it mentions the king of England. It didn't say Queen Anne. It says the King of England. It didn't say King of Great Britain. It didn't say King of Scotland. It said King of England. So that capacity of that office is right here. That's now called a corporation sole because New Jersey has secularized our ancient law, our historical law. Okay? Very, very important that you take heed to what the capacity of the said ancestors as kings are telling you today through me. See, people pay attention when it start to pay attention when it's too late. That's the problem. I've been doing this, teaching this for a minute. But when they get in court and foreclosure court, all right, or bankruptcy court, then this is what they fall subject to: the gag system. Okay, they have strict procedural guidelines for the gag system, which is strict forfeiture. Federal law prioritizes the rights of the wealthy lord or lender. Do you hear that? Lords or lenders. That's why we go to the preamble of the Constitution. They give it a pronoun. It says he. He. The lord or lender, if a borrower missed the payment deadline, the law date 30 years, by evening hour, the feudal lords used their courts to strip away the borrower's land permanently. Through eminent domain, through escheatment, through adverse possession, whatever process they got, they use it. These elements are still used today. I'm only on page 3, brothers and sisters. This is just page 3. Look how much you're learning just from 3 pages. Foreclosure. This concept directly involves from the medieval process where a lord officially terminates a borrower's right to reclaim their land. I'm going to show you how they did it. I got the actual documents already written up. I already got the documents already written up, brothers and sisters, to deal with this situation. I already got it. Ready to be given out. Notice of pre-litigation disclosure request and notice of underwriting error. Okay? We can't even get into this, all right, nor the complaint that I prepared until you understand the origin of why we filed the complaint. So let's go back to the origin. So elements we still use today. Foreclosure, this concept directly involves from the medieval process where lords officially terminated a borrower's right to reclaim their land. How could you be terminated from land that you own because of a debt that they just created out of thin air? The concept of a lien. While modern buyers get the property title immediately, the bank retains the financial interest of a lien that reflects the old feudal practice of holding security over the property. Did you hear that? They have a security interest on it. All right? So if you default on the mortgage, a dead pledge, then guess what? You're going to lose your property. If you pay off your property, you might retain, you might have the deed discharge, the loan discharge, but you still got to pay taxes. Still got to pay taxes. Either way, you're duped. All right? All this is because of one document that they issue. Okay? One document, which every one of you carry in your pocket today. One document took us from citizens, nationals, all right, to becoming what we call consumers. Consumers. Customers. You are now customers, consumers, all right, which allow these corporations to now place liens on the customer, the consumer, okay? Let's see how they did it. Let's see how they did it. Under New Jersey statute annotated, I'm going to use these statutes as an example because we're in New Jersey, all right? But under the Real ID Act 2025, it applies to all. A standard New Jersey driver license or a state identification card, listen, y'all, listen. Look in your pockets, look in your wallets, look in your purses, all right? In New Jersey or any other state under the statute governing the driving license, it is in fact a state identification card which possesses no capacity to properly identify you. The only thing that it does, it has a limited identification capacity. Hear what I said? A limited identification capacity, meaning that it's only there to visually identify you. It does not denote to your capacity or status to in fact contract. Because the contract, you must have the capacity to contract, which means you must have some legality. The statute specifically mandates that these state-issued cards cannot be used as a legal evidence to establish or verify an individual's citizenship, nationality, or precise legal status. When we say status, we're talking about capacity. The only thing that it does serve as a limited identification card to establish the capacity for individual identity visualization. That's it. That's it. Okay? The things that you do have in your possession, all right, that does show some limited capacity status is your birth certificate and your social security card. All right? When combined with the birth certificate and social security card, these statutory limitations form a powerful argument regarding why any mortgage or bank pre-contractable failure to verify your true capacity to contract. Once again, when you combine your birth certificate or social security card, this statutory limitation forms a powerful argument, claim, merit review, declaratory regarding how a mortgage pre-contractable contract failure to verify the other party's true capacity to be able to contract. And it's not just based upon a visual identification, but it's based upon status, capacity as a citizen or a national of a state. That is the only way you have the capacity to contract. Okay? The only other way is as a consumer. The legal connection outlines how these specific instruments impact your contract challenge. Okay? Or as I would say, our contract challenge. The legal defect. We're on page 4. The legal defect in banks verification. Under federal and state banking laws, a lender must precisely verify the exact legal capacity and political status of a party signing a mortgage. Did you hear that? Did you hear that? I'm going to say it again. Under federal and state banking laws, a lender must precisely verify the exact legal capacity and political status of a party signing a mortgage. Okay? Now remember, you are a citizen. You're supposed to be a national. You're protected by the 14th Amendment. That determines your citizenship. The birth certificate, which is a limited capacity, determines the place or abode and boundaries where you were born. Okay? But banks, okay, through their algorithm systematic systems that were created, i.e. financial technology, they rely primarily on one standard instrument called a driving license, an instrument that falls under New Jersey Revised Statute 39, colon 3-29.3, which explicitly strips of any power to prove citizenship or status. Mortgage companies or banks use a legally deficient method to establish your contracting capacity, and they treated you as a standard individual commercial debtor under Title 46 while ignoring your actual specialized legal status under 46.3-2. All right? Why? Let's go back there. Forty-six point 3-2. As English Americans, our capacity, even if we didn't know we had this capacity, remained intact well before July 4th, 1776. We know that because the 14th Amendment. When they passed the 14th Amendment, they restored our capacity known as folk right. Okay, folk right. Supreme Court has stated this in the latest Supreme Court ruling with Donald Trump, as well as in the latest case establishing citizenship, Juan Kimmel Art. They said that the 14th Amendment returned the folk right to the original inhabitants who created what we call folk right, because the colonists took it as their own, but yet they were colonists. Okay? These are the ones who came after July 4th, 1776. Okay? Very important. And then they took it as their own by way of amending the retained unenumerated rights that were passed out by our ancestors going back to the time immemorial before William the Conqueror created the feudal system. All right? And then have declared by section February 18th, 1795 that now they have changed our intel estate into what they call fee simple, to what we call free and common soakage, which is a type of estate which is paid by way of what we call a tax. A tax. Okay? This is the legislative statute historically preserving and declaring and showing what the state did when they stepped into the king's shoes, to the king's capacity, which they don't have, because the only one that can have that capacity is a corporation soul. So by relying primarily, I didn't say that. The statute says that. So by relying primarily on a standard driver license, an instrument governed under the New Jersey Revised Statute, Title 39, colon 3-29.3, explicitly stripped of any power to prove citizenship or status. So they said this statute right here strip any person who used that instrument denoting to prove citizenship or immigration status, i.e. capacity. All right? Rocket Mortgage used a legally deficient method to establish your contracting capacity when the actual instrument that governs the instrument says that it does not authorize that type of capacity in regards to who holds the car. Very important for you to understand that. Let's look at the statute. New Jersey Revised Statute 39 3-29.3. Identification cards. Everyone have one in their pocket, so don't tell me you don't. A person issued an identification card pursuant to this section may be issued a standard identification card or real ID identification card. The Chief Administration require any applicant for a standard identification card to provide as proof of the applicant's identity, age, and residence, primarily a secondary document with which the Chief Administration should attribute points values in accordance with the point-based identification verification program established pursuant to Section 28 of Public Law 2003. Any document, any personal information, including an applicant's photograph, visual identification. You hear that? Visual identification, not status and capacity, because it said it right there. Photograph obtained by the Commission for an applicant for a standard identification card should be confidential and should not be considered a government record. Did you hear that? So that driver license that you have, which is a standard identification card, is not part of a government record, nor is it construed to the Public Record Act, which is Title 47, colon 1-A, the Open Public Record Act, meaning that it's not part of a government issued ID. But isn't that what they're telling you? Is it a government ID? But it says it's not, should not be considered a government record pursuant to public law, which is to govern the public access to the public record, or the common law concerning access to government record. You hear that? Or the common law concerning the access to government record. It should not be disclosed by any commission for any purpose related to Title 8 of the United States Code without the informed consent of the applicant. Title 8 governs nationality and immigration status. Okay? Title 8, Section 4, United States Code 1401 governs Nationality and Immigration Act, dealing with citizenship, nationals, or naturalized citizens. Y'all better listen to me. That ID, that instrument is only served for visual identification and had nothing to do with the proving that you are in fact a citizen. It just said it. It also says possession of a standard identification card issued pursuant to this section should not be considered evidence of an individual's citizenship or immigration status. It should not be used as a basis for an investigation, for an arrest, citation, prosecution, or detention. Did you hear that? So let's go back to the lesson plan. So under federal law and state law, Banking laws, a lender must precisely verify the exact legal capacity and political status of a party signing a mortgage. They don't do that. Why? Because the only thing they use is a visual identification such as a driving license, which does not denote your capacity because it does not prove that you are in fact are an immigrant or a citizen or a national, or it does not prove that you are in fact part of the public record under the common law. It said that via the verbiage, the plain language of that said statute. Do anyone agree with me out there? Why is it so hard for y'all to get this when someone is actually trying to tell you the truth? Point two, birth certificate and social security card defines private capacity. Okay? A birth certificate and a social security card are foundational instruments that establish your distinct private personhood and your organic birthright status as an English American citizen under the 14th Amendment. Let's stop right there. Citizen, your birth social security card is just an instrument that denote to the tangible things that are associated with you as a result of you being born within a particular domicile. Okay? Place of birth. The 14th Amendment established the capacity that makes you an actual citizen, but you have nothing in your possession to prove that you're in fact a citizen other than the declaration of the supreme law of the land, which is the 14th Amendment. Okay? None of these other instruments that they give you from the state can prove that you in fact have an inherited common law folk right. Okay? The only way you can do that is understand your capacity as an English American. All right, under the 14th Amendment, because that's what made you an English American. Okay, very important. These documents reflect your inherited common law folk rights, especially your spiritual rights or spiritual capacity that's reserved under what? The church. In lieu of your interest of the inheritance that reserved from the king or the corporation, so modernly called, as a result of that capacity that has a right to the continuity and preservation of the estates as set forth by New Jersey Revised Statute 46-2 before they stepped into the king's shoes on February 18th, 1795, which is the same language of the said statute we just read. Okay? But that's your rights. This is your folk rights, not theirs. Okay? When we, as the children of God, i.e., the English Anglo-Saxon Berbers, i.e., the Christians, when our manifestation or personification or incorporation manifested based upon the birthright, based upon the birth certificate, as well as the Title 14 of the United States Code, that reserved our retrospective rights that were called the notice ultimately those born abroad. Okay? When England was over there. But now that England was here in North America from 1702 to 1776, there's no need for the application of Title 8 of the United States Code, Section 1401. There's no need for the birth certificate because this, in fact, proves that we had a permanent domicile where before the colonists had set up their shop. Because a birth certificate represents a biological birthright to the land, it directly conflicts with the bank's attempt to use an automatic digital transaction to reduce your property holding to a simple corporate debt contract via that driver's license. Okay? That did it. That made you a consumer. How I know it? Let's read it. There was no meeting of the minds. Our statutory analysis claim is that a fatal defect occurred during the pre-contractual phase when we all signed that mortgage deed at that closing. And all because of that damn driver license, okay? Majority don't have a religious credentials. The only credentials that you do have is a birth certificate, and they created that as well. So it's in fact limited to your full capacity because it does not establish your citizenship. It just establishes place of birth. What establishes your citizenship is the 14th Amendment, and that must be construed to the common law. I didn't say that. The Supreme Court said that in 1 Kemah Art. Okay? And that's based upon in light of the history of the common law, which goes back to Anglo-Saxon law, which is entailed called folk right. Okay? Folk right. That is your right. Let's see what Anglo-Saxon law. Let's look at it. Because the statute we're reading are the codes and law. Anglo-Saxon law. Later Lagu, law and doom decree, judgment. This is why William the Conqueror called it the Doomsday Book. Was a legal system of Anglo-Saxon England from the 6th century until who? William the Conqueror, through the Norman conquest, invaded England. It was a form of what we call, or assumed to be, Germanic law, but we know it wasn't Germanic law because Germanic laws were those who immigrated to England when they crossed the Rhine, going back into the 5th and 6th century. It says it's based on an unwritten custom known as folk right and on written laws enacted by kings with the advice of their written or council. When we go back to the 1911 Encyclopedia Britannica, they say that the written was that of same system created by the Berbers. By the later Anglo-Saxon period, a system of courts had developed to administer the law, while enforcement was the responsibility of what? The aldermen and the royal officials such as the sheriff. When you go to the court right now, who do you see in the sheriff courthouse? Who do you see in the courthouse? Sheriffs. Okay? These are your officers. Okay? But you must know your capacity. We didn't need lawyers. We went to the courthouse ourselves because we understand the purpose of jurisdiction. Being born within the territory of the king. We understood it. Let's go back. So this is your law, folk right. How many of you are out there on YouTube, TikTok, are teaching you folk right? Banks, mortgage companies, this one in particular, Rocket Mortgage, automatic digital system completely failed to analyze these separate capacities. What separate capacities? Visual, identification, and status and capacity. They mistakenly assume our driver license authorized them to bind our estate into a standard Title 46 commercial term under the amending of Title 46-2 to a free and common circuit, which allows them to now tax your ass. Because they underwrote a commercial consumer loan instead of a specialized corporate sole temporal sanctuary holding. There was no valid meeting of the minds in making a contract, which makes the contract voidable. You hear that? Makes it voidable. Let's see how. Let's see how. In closing, the driver license is the most preferred instrument used in closings. They prefer the picture ID by way of what we call a driver license. We are entirely right about how closing rooms operate in the real world. A state-issued driver license is absolutely the most preferred required form of primary picture identification for a standard real estate closing. It has nothing to do with your capacity, because we just read what New Jersey Revised Statute 39-29.3 said. It had nothing to do with your citizenship, it had nothing to do with your immigration status, it had nothing to do with the public record, government, common law, etc. That's what it said, but yet the closing agents require that to close on the deal, which does not make you the purchaser of a property. It makes you the consumer who purchased the property. All right? You are entirely right about how closing rooms operate in the real world. A state-issued driver license is absolutely the most preferred and required form of primary picture identification for any standard real estate closing. Settlement agents, underwriters, and automatic fintech systems like Rocket Mortgage are trained to demand a valid driver license to confirm that the person sitting at the table matches the name on the debt paperwork. Did you hear that? It's the same person sitting across the table. It's the same person on the paperwork that they drew up. Okay? Which made you a debtor. Mortgage debtor. Mortgage. A dead pledge. Understand the madness. However, by you listening to me, your legal insight, based upon teaching and educational purposes, will now uncover a massive structural trap within New Jersey's own statutes. While the banking industry uses your driver's license as an absolute requirement for visual identity validation, the legislature has stripped that same document of its substantive legal status under New Jersey Revised Statute 39:329.3. We just read it. This dynamic creates a fatal conflict in the bank's underwriting process, which strengthens not just my argument, but as well as your argument if you sit and watch this class. Okay? Very, 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 very important. In order for you to understand that, let's understand visual verification versus substantive capacity. We must understand the two. Write that down. Visual capacity versus substantive capacity. How many of you understand the difference between the two? Hold that thought, everyone. Sorry about that. Once again, I promise you, if you stick with me, you'll be able to save your property from foreclosure. I got the whole process set up. If you want to have a private class, just send me a text in the comment, and we can get it started. Okay. I do private classes. I understand that a lot of our brothers and sisters are suffering from these situations, but sometimes it can be overwhelming when you've been doing this for a while and no one seems to listen. Okay? But if you have the courage and you want to be able to exercise your full capacity as homeowners, then please stay and watch this lecture. Okay? Pass it on to your brothers, your sisters, your friends, aunts and uncle. Have some courage. Visual verification versus substantial capacity. Very important. When you're looking at that driver license that's in your pocket, but that's the only in your pocket. That's the only thing that you have right now that you can actually use to identify you. But we know now it only visually verifies who you are, but it does not show you your substantial capacity, i.e., your rights. When you hand over your driver license to anybody, let alone as a closing, Rocket Mortgages uses it strictly as a visual anchor to check a box. Prescriptive. When you hand over your driver license at the closing, Rocket Mortgage uses a strictly as a visual anchor to check a box. This is reason why we send them notice of pre-litigation disclosure request and notice of underwriting error. Okay, this is what you send them. All right, but you just can't make a claim and don't understand what your claim is about. This is why I'm teaching you for educational and teaching purposes, so that you can understand the legality of why you're learning this. Okay, very important. Notice of pre-litigation disclosure request and notice of underwriting error. How many of you know how to prepare a litigation instrument in lieu of disclosure of an error that was not done by you? How many of you know that? Stick around. When you hand over your driver license, which pretty sure all you did, at the closing, when you sign at the closing, all right, of your mortgage, their pledge, they strictly use to anchor in you as a consumer, a debtor, by checking a box. But under the plain language of the instrument that they use in lieu of checking that box, which was under in New Jersey under the statute 39:3-29.3, that license possess a strict limited identification capacity. You hear that? It possesses a strict limited identification capacity, which means it only serves to visually identify you. Only. It is specifically barred from serving as any legal evidence of your political status, citizenship, or nationality. Think about that for a second. Think about that for a second. Right there, you should be hooked. You should be hooked right there. So when you all bought your houses, you had no capacity to buy the house. All right? Because first of all, you can't own property if you're not a citizen. You can't be a citizen if you don't have a nationality. Lacking the both, you have no political status, i.e., you have no capacity to even have a claim to have an interest in the home you claim to own. Let's look at the conflict. The bank uses a document that legally cannot prove your status as a national or a citizen, nor can they show your capacity to contract to bind you into a sweeping commercial Title 46 contract. Okay? Which we know under free and common sokas, they made you a debtor because now they're able to tax you, when prior to that, you owned it allodial because it was from the king. They only stepped into the king's shoes by way of amending our laws that were back there through time immemorial by prospectively creating a law that legislatively reached back retrospectively into time immemorial. When 1189 says you could not do that. Okay? Time immemorial. Look it up. The conflict. The bank uses a document that legally cannot prove your sovereign nationality or contracting capacity to bind you into a secret commercial Title 46 contract under New Jersey Vice Statute 4613-2, which does not deal with capacity, it deals with interest denoting with property. Interest runs with the land, okay? But the capacity to have an interest that runs with the land comes from somewhere else. Visual verification versus substantial capacity. Now you know the two. Two, overriding the preferred ID with your solving instrument. Now, a lot of you might not be in this situation because you didn't understand these lessons yet. Okay, but now you do. Okay? Now closings is done. Right? Closing is done. Now they got a lien on it and there's a compass on it because you fell into the consumer trap. So now what do you do about it? What do you do about it? Is there anything we can do about it? Because Rocket Mortgage or any mortgage company or any bank has accepted your preferred picture ID, which only serves for visual verification, they were legally obligated to look at the other foundational instruments you provided. Did you provide your birth certificate? Probably some of you did. Did you provide your social security card? Some of you did. Did you provide your religious credential? No. This determines your actual capacity to contract. Why? Because if you don't have a spiritual capacity, then you have a secular capacity. This makes you a secular consumer. What is secular consumer? Let's look at that real quick. Secular consumerism refers to the way modern non-religious societies use consumption, especially of non-essential goods, as a substitute for traditional religious or spiritual practices, providing identity, belonging, and purpose. In this field, shopping, brand loyalty, and luxury purchases function like rituals in a secular religion, offering emotional satisfaction and social cohesion. Did y'all hear that? Did y'all hear that? Secular consumerism refers to the way modern non-religious societies, that means you, use consumption, especially of non-essential goods, as a substitute for traditional religious or spiritual practices, providing identity, belonging, and purpose. In this field, shopping, brand loyalty, and luxury purchases function like rituals in a secular religion, offering emotional satisfaction and social cohesion. I'm not even going to go into how it works. I'm not even going to do that. Let's go back to origin. We're only on page 6. Those foundational papers reflect your organic birthright status and private capacity as an English American citizen. So a birth certificate and a social security card only denote to an American citizen. The 14th Amendment denote to an English American citizen because Juan Kim Ark and the Supreme Court said that citizenship for the 14th Amendment, under the 14th Amendment, which was exclusively for emancipated slaves, must be construed to the English common law in light of their history. Okay? Very important. So by channeling that identity through registering with me, the Title 16 Corporation Sole, which is the Office of the Crown, you have placed a protected non-commercial shield around what? Your real estate, as provided by said statute before they stepped into the shoes. Okay? Before they stepped into the shoes. Point 3. The core of the statutory analysis, whether you're in sending a referral letter, all right, to the mortgage company or the bank, or you're filing a equitable claim in a court of law, because you're gonna give them the opportunity to correct their mistake. Okay, very important. All right, before we file our lawsuit, we're going to hit them with what? A notice of pre-litigation disclosure request and notice of the underwriting error that has occurred because of that damn driving license. Okay? We're going to do that first. You give them 30 days. They don't respond, then you got grounds to file a lawsuit in lieu of equitable redemption. 1 second. So instead of saying my lawsuit or your lawsuit, our lawsuit should force on the mortgage companies into a corner because of the preferred ID loop. We are going to tell the chancery judge, because that's the court you should be in, a court of chancery, okay, where you have the only chance you're going to have, okay, in lieu of equitable redemption, all right? What are we going to tell the judge if we have to go to court? Rocket Mortgage or any mortgage bank demanded my driving license for picture ID, which I provided, but they treated the license as a blank check to assume I was a standard secular consumer. You hear that? Secular consumer. We just read that, what that was, all right? Based upon them stepping to the shoes of the king, all right, under 46 colon 3-2, by way of amending that statute February 18, 1795, they completely ignored that under New Jersey law, under New Jersey Revised Statute 39 29.3, that the license cannot establish my contractual status. You hear that? The automatic system was blind to my actual birthright document and my Title 16 corporation sole capacity, resulting in a complete failure to retrieve a true meaning of the minds. What is true meaning of the minds? How do you know what that is? Let's look at it. Meeting of the minds. Right here. Can't make this up. Under the formula, let me make sure y'all see this. Under the formulist theory of contract, every contract must have 6 elements: an offer, an acceptance, and consideration. Meeting of the minds, capacity, and legality. Did you hear that? Many other contracts, but not all types of contracts, also must be in writing and be signed by a responsible party in the element called form. You hear that? Form. I'm going to read it again. Under the formulist theory of contract, every contract must have 6 elements: offer, acceptance, and consideration. Meeting of the minds, capacity, and legality. You hear that? What is capacity? 1 second. What is capacity? Let's see. Capacity. Legal capacity is a quality denoting either the legal aptitude of a person to have the right and liabilities or the personhood itself in regards to an entity other than a natural person. They're talking about corporations and natural people. But the consumer is neither one. The consumer is neither one. You must have capacity and legality. Legality is the state of being consistent with the law, the construct of a legal power or lawfulness in a given jurisdiction. Come on, brothers and sisters. This ain't hard. Vices of consent. Mutual assent is uh, vitiated by actions such as fraud, undue influence, duress, mutual mistake, or misrepresentation. This may render a contract void, unenforceable, or adhesionable. All right? Y'all better listen to your king. All right? Very important. Very important. Let's go back to the origin. Excuse me, I'm sorry. The absolute contradiction in the text. When you line up the plain language of the two statutes side by side, that's uh, the statute governing notaries, okay, and their actions at a closing, all right, in lieu of a mortgage between the contractual parties at what we call the meeting of the minds, all right. You must have the capacity and legality, all right. So when you line up the plain language of both statutes, all right, side by side, you find a fatal flaw in the mortgage underwriting process. Before we read the language, let's read the actual statute. Once again, 39:3, 39:3-29.3 of New Jersey Revised Statute. 39:3-29.3. Possession of a standard identification card issued pursuant to this section. Pursuant to this section should not be considered evidence of an individual's capacity. You hear that? Capacity. But yet they haul your asses up, arrest you, cite you, prosecute you, and detain you, or investigate you. But it said it should not be used to do such a thing. So your rights should be embodied. Why? Because you are not a citizen. Okay? Nor you're a national, nor you're a naturalized citizen. You don't fit any of those requirements. I just proved it, hands down. Let's look at the other one. Title 52. State government departments and officers. Requirement of certain notarial acts. Okay? Requirement of certain notarial acts. This is the capacity that the state of New Jersey practices their eminent domain power, which is under Title 20, a separate statute. Okay? Very important. For the purpose of this section, a notarial officer has personal knowledge of the identity of an individual. It didn't say capacity, did it? Preparing before the notarial officer if the individual is personally known to the notarial officer through dealing sufficient to provide reasonable certainty that the individual has the identity claimed. Visual identity. 2. A notarial officer has satisfactory evidence of the identity of an individual appearing before the notarial officer if the notarial officer can identify the individual by means of A passport, driving license, or a government-issued non-driving license identification card, which is current or expired no more than 3 years before the performance of the Notarial Act. Did you hear that? But the said statute just said that the driving license is not proof of what? Or considered evidence of an individual citizenship or immigration status. Think about that, brothers and sisters. I ain't moving. Think about that for a second. All right? And realize that if you turn from this channel, you are making a grave mistake. Because we just read, when you line up the plain language of the statute, this is called declaratory review or declaratory analysis for injunctive relief. This is the only relief you can get in a chancery court. You're not asking for money. You're not asking, you ain't saying you own anything. You're going to let the law say it. Okay? The closing mandate for any mortgage company or bank under the statute that you just read that was delegated by the state of New Jersey, the sovereign, okay, based upon the 4 sovereign powers: tax, eminent domain, escheatment, and what's the other one? Foreclosure. Okay? That's the 4 pillars of the state sovereignty. The closing mandate under the statute we just read, this code states that a notary or closing officer has satisfactory evidence of your identity if they verify using a current passport, driver license, or government-issued non-driver identification card. I didn't say a birth certificate. I didn't say a social security card, even though they asked for your social security number. Nor did they ask for some type of credential from your religious affiliation. Okay, your church. Now here comes the legislative block. Okay. New Jersey Revised Statute 3-29.3 says this code states that a standard New Jersey driver license or identification card should not be considered evidence of an individual citizenship or immigration status. It doesn't. Now we expose the consumer loop. By exposing the specific code loop, our lawsuit can present a flawless textual challenge to the chancery judge, whoever that judge is. By what? 1, divisible only loophole. Divisible only loophole is that Rockets Mortgage or any bank complied with the identification rule of New Jersey Revised Statute 52:7-10.8, strictly to verify your face and your signature at the closing table. Okay, that's material facts, substantive evidence that you can support your claim if they deny your right to request what it was called. When we request the pre-litigation disclosure request and notice of underwriting error, if they deny that request, then you have grounds to file a chancery complaint in lieu of declaratory injunctive relief. Okay? Give them 30 days. Divisible only loophole. Rocket Mortgage complied with the identification rule of New Jersey Revised Statute 52:7-10.8, strictly to verify your face through facial recognition, okay, and your signature at the closing table. 2, the ultimate failure to establish status. The mortgage company or the bank automated underwriting software treated that driving license check as the absolute legal proof that you were entering the contract as a standard commercial secular debtor under Title 46-3-2. And I explained how they did that by way of the language of the statute. The disregard to the truth. They disregarded the truth. They completely ignored that the language of 39:3-29.3 explicitly stripped that instrument, driving license or non-driver license or identification card, of any power whatsoever to prove your substantial status or your contracting capacity. Totally stripped it. How many of you understand that so far? How many of you understand that so far? Okay. Because Rocket Mortgage rely entirely on the automatic picture ID check that has zero statutory capacity to establish nationality, they completely fail to underwrite your actual foundational birthright documents, whether it was your birth certificate, social security card, or your registered religious documentation, or any affiliation that you have outside of that driving license that they give you. This is an exact reason why our strategy demands a statutory analysis from the judge, and before we request it from the judge, we're gonna request it from them. Okay? Our focus, we are forcing the court to rule that the mortgage company or the banking company used a visually compliant ID check to mask a total failure to achieve a lawful substantial meeting of the minds. You hear that? Point two. We are only on page 8. This groundhog keep eating up my flowers. If you want to send me email, my email is cliffordjeb@gmail.com. cliffordjeb@gmail.com, which is cliffordjeb@gmail.com. If you want private lessons, please hit me up. All right. 2. The Federal Bank Rule 31 Code of Federal Regulations, Section 1020.220. The CIP rule. All right? Very important. CIP rule. Because Rocket Mortgage or Bank is a financial technology lender, they are governed by the Federal Customer Identification Program, requiring under Title 31 of the Code of Federal Regulations 1020.220, derived from Section 326 of the United States of America Patriot Act. This federal regulation forces banks to implement a strict Know Your Customer called KYC Identity Verification Loop. Let's check that out. Not your religious customer, but your secular customer. Know your customer or know your client, laws, regulation, and guideline is a financial services require regulated businesses and professionals to verify the identity and suitability and risk involved with maintaining a business relationship with a customer. These procedures fit within the broader scope of anti-money laundering and counterterrorism financing. KYC. Know your client or customer. Okay? Very important. Why? Because they are a financial technology corporation. What is financial technology? What is it? It's called fintech. Financial technology, abbreviated as fintech, refers to the application of new technologies to products and services in financial industry. This broad term encompasses a wide array of technological tools in financial services, including mobile banking, online lending platforms, digital payment systems, robo-advisors, and blockchain-based applications such as cryptocurrency. Financial technology companies include both startups and established technology and financial firms that aim to improve, complement, or replace traditional financial services, i.e., overriding, underwriting, etc. Y'all better listen to me, brothers and sisters. Y'all better listen to me. That brings up consumer. Hence the word consume. Hence the word custom. Consumer, customer, custom. Consumer is a person or a group who intends to order or to use purchased goods, products, or services primarily for personal, social, family, household, or similar needs, who is not directly related to entrepreneurial or business activity. The term most commonly refers to a person who purchases goods and services for personal use. Okay? Very important that you understand this from this point of view. Do the federal banking rule, Federal Code 31, governed under the Customer Identification Program, CIP. All right? This federal regulation forces banks to implement a strict Know Your Customer identity verification loop. Rocket Mortgage or any mortgage company digital system or program to require a government-issued photo ID, i.e. your driver license, to prevent identity theft and money laundering. We know it because we just read said statute. Okay? We just read the said statute to validate that. But yet, the said instrument they use to validate the identity does not show your capacity as an immigrant or citizen, nor your ability to contract, because you must have the capacity. So this is a structural paradox that wins our complaint. Through our statutory analysis, which is through declaratory analysis in lieu of adjunctive relief. This is where Rocket Mortgage automated closing process breaks down under the statutory analysis strategy. On the New Jersey Revised Statute Annotated 52:7-18 and 19, as well as Know Your Customer Federal Code 31, Section 1020.220, they use a driver license for visual identification only with no need of capacity or status as a citizen or an immigrant, okay? And your ability to be able to have the capacity and legality to contract. This contradicts the bank loop, okay? Why? Because of what the language of the New Jersey Revised Statute says under 39:3-29.3, governing instrument they use to validate the visual identification, which is the driver license, which has stripped every legal substantive capacity that you could ever have as a citizen or a national, etc. Okay? You must understand how important this lecture is. The bank error. The bank error. Rocket Mortgage or any mortgage company complied with the visual photo ID check mandated by said statute 52:7-18, as well as the federal CIP rule, Know Your Customer. However, the automated software treated that visual identification check as an automatic contractual consent to force a standard Title 46 commercial contract onto your allodial estate, which was governed under 46:6 under the revised statute. They just made it free and simple because they converted it from entail to fee simple under the common recovery practice, which we'll discuss later on in this lecture. The legislative law. They have completely ignored that the language in the said statute governing the driver license stripped away all power to prove your substantive legal status and political contracting capacity. Because the bank relied blindly on a photo ID document that possessed a strict limited statutory identity capacity, they completely fail to analyze your actual birth certificate, social security card, or any instrument that shows you have a capacity. All right. This ensures that under that upcoming declaratory judgment action that we are assumed to file, if they fail to respond to our for our what we call it notice of pre-litigation disclosure inquiry in lieu of underwriting error. All right. This ensures that the upcoming declaratory judgment action, we can prove that the mortgage company or the bank used a flawed automatic identity check to manufacture the illusion of a willing participant, leading to a complete failure to achieve lawful meaning of the minds. Do you understand this? All right. Did you understand that? All right. So we're going to end this lesson and we're going to go into, in the next lecture, how mortgage evolved. How did the mortgage evolve? And that came through what? The process of what we call common recovery. Okay? So please, brothers and sisters, understand how important my time is. Okay? All right? It's not to lead you astray, but to guide you back into regaining your inheritance through the law, okay, by restoring your capacity that you were born with, okay? You were born with the said capacity. I didn't say it, the Constitution said it. Let's look at it before I close. Right here. We, the people of the state of New Jersey, grateful to Almighty God for the civil and religious liberty which He has so long permitted us to enjoy, and looking to Him, give Him a pronoun, for a blessing upon our endeavors to secure and transmit the same unimpaired to succeeding generations, do ordain and establish this Constitution. 1. Section 1 of Article 1. All persons are by nature free and independent and have certain natural and unalienable rights, among which are those of enjoying, defending life and liberty, and acquiring, possessing, and protecting property, and of pursuing and obtaining safety and happiness. Why? Because you are the popular people. Section 2 says it. All political power is inherited in the people. This is your capacity. So what instrument did the government give you that shows that you have the political power? Government is instituted for the protection, security, and benefit of the people, and they have the right at all times to alter or reform the same whenever the public may require it. Okay? Let's go here. Article 821. Where is it at? Page 3. I don't like this one. Let me find another one. All that thought. Section 1, right here. The most important clause. This enumeration of rights and privileges should not be construed to impair or deny others retained by the people. You hear that? This enumeration, which means this shit that's written down, we read it right now. Okay? That means the Constitution, the statutes, the codes, the case law, state dices, those don't mean shit. Because we had rights that we were born with. That's why I said the writing, the enumerations, the underwriting of the rights and privileges should not be construed to impair or deny others retained by the people. What rights that were retained by the people that were not enumerated? That was the common law. This right here. We the people. The preamble. We the people of the state of New Jersey, grateful to our Almighty God for the civil and religious liberty which He has so long. He, not she. He, that's a capacity permitted us to enjoy, and looking to Him for the blessing upon our endeavors to secure and transmit the same unimpaired to succeeding generations to ordain and establish this Constitution. That is the capacity. That's the purpose of the capacity in lieu of the continuity of preservation of the land. Okay? That's through the crown. The corporation sole, which is governed under 16:1-28. Right here. English common law never developed a concept of the state, which you're in now. It left supreme executive power with the king. The concept is now in modern day called what? A corporation sole, which stemmed from the Kingdom of England. What is a corporation sole? A corporation sole is a legal entity consisting of a single sole incorporated office occupied by a single natural person. Okay? Representing what? The crown. What is the crown? Or what is the purpose of the crown? Right here. Right here. The concept of the crown took form under the feudal system. Though not used this way in all countries that had this system, in England all rights and privileges were ultimately bestowed by the ruler. Land, for instance, was granted by the crown to lords by exchange for feudal services, and they in turn granted the land to lesser lords. You hear that? Once exception to this was common socage. Owners of the land held a socage held it subject only to the crown. With such land become owners, they are said to exceed, i.e. return direct ownership to the crown, i.e. crown land, by which own property, primarily unclaimed inheritance, becomes the property of the crown. It's called crown land. What is crown land? Crown land, also known as royal domain, is a territorial area belonging to the monarch who personifies the crown. Okay? It is the equivalent of an entail estate. An entail estate is different from a fee simple estate because fee simple estate was stolen through a practice of what? Common recovery, which we're going to talk about in part 2. B tells a legal concept set of associated rules restricting the manner of which real property passes from one generation to the next. That's what they were talking about in the preamble, brothers and sisters. Continuity of possession of said property. All right, so with that, I'm going to close. and hope that you brothers and sisters will join me tonight at 6:30. Okay, I'll be back again at 6:30 tonight with part 2. Peace, my beloved.